submitters, which was a grave omission on my part. But of course, they come in, or you come in, and anyone else that might wish to be heard in relation to their submissions come in late on today. And if you are coming in and out, which is your right, I wonder if you might just check in with Miss Wilson mid-afternoon, because there is a possibility that we may be able to hear you later today, depending on how we get on. But if we cannot, we will certainly hear you first thing tomorrow morning at 9 o'clock. Is that acceptable to you?
Yes, that's fine, thank you.
Okay. Now, my approach with these hearings, for those who don't know me, and some of you do, but for those who don't, I take the full liberty granted by the RMA to conduct the proceedings in what I deem to be the most helpful way to get to our end goal. One thing I am not allowed to do, of course, is allow cross-examination, but I do allow people to ask through me clarification of anybody, but rather than by interjection, which is frowned upon, you need to, at the end of that person's giving their submissions or evidence, to raise your hand and gain my attention. And I am open to questions. And if I deem them to be appropriate questions, I will invite the questionee to respond. Is anybody in need of any further explanation as to the process? If so, speak now, or raise your hand, or do whatever to gain my attention.
How do you raise your hand to gain your attention through Teams?
Good question. Ms. Wilson, can you help us?
Certainly can. There we go. So Pat's just shown. So across the top of the Teams screen, you will see reactions is one of the little icons there. So if you click on that, it'll give you option to raise your hand. I think that's right, isn't it, Brett? Yeah. Or you could also put a message, I guess, in the conversation as well, if you wish to.
I wonder, Ms. Wilson, could I ask you to monitor,
yes, of course,
for any such requests in case I do not become aware of them?
Of course.
And make sure that I don't ignore anybody who wishes to speak.
Yeah, well done.
Thank you for that. Any other questions before I invite Ms. Lupus to address us? It appears not. So, Ms. Lupus, the floor is yours to present the case for the applicant as you deem appropriate.
Thank you, sir. Your camera has frozen for me, but I'm not sure if that's the case for everyone else. Ms. Wilson, maybe you could let me know if you can. There you go.
How's that? I was just using a split screen and trying to be smart, but
that was fun. You did have a smile on your face, so it was okay. But I thought I might see how you were reacting as we went through. So my team's online in various locations. I have everyone online and on standby. We had a draft schedule that Ms. Wilson has given to you, but I am aware that's very dependent on your questions. So we may well step through much, much faster, depending on whether or not you'd like people to take you through a summary of their evidence or go straight to questions at the start. I'm in your hands on that. Everyone does have some short speaking notes just to set the scene for their briefs.
May I comment on that immediately? It's a very good point, and I have read the papers as I'm expected to, I have already perceived that the critical issues are the gateway test. And if you can persuade me that the gateway test is met, then it comes down to environmental effects and objectives and policies in the plan. As your Ms. McGrath has, I was going to say pontificated upon, that's not a very kind word. She has analysed and expressed her opinion, which happens to be diametrically opposed to Mr. Hartstone's. So in your submissions, which I have read, thank you for giving them to me in advance, you might like to particularly focus on those issues which obviously I'm going to have to consider very carefully. But back to you.
Thank you, sir. The one expert who has prepared visual presentation is Mr. Farrow. He will take you through a little bit more detail because that we have filed that visual presentation, but I've asked him to speak to that since it is quite critical in respect of that key issue of rural character and landscape amenity. Mr. Farrow, I have to let you know, has tested positive for COVID a couple of days ago, but is soldiering on from home, but is may just be a little bit croaky as he goes through, but he is otherwise feeling well.
He's Mike F on my screen, I take it.
Yes, and
he
is.
Thank him for that very helpful visual presentation. I know the area, as I've indicated in general terms, and I will expect at the close of proceedings you to address me on the question of whether a specific site visit is required or not. But we'll hold that question open at the moment. But back to you.
Thank you, sir. You may, I would at the outset suggest that a site visit would be quite useful, in particular in respect of the topography of the site, given that is one of the key issues between Mr. Kensington and Mr. Farrow. But once we've been through that visual presentation, we might have another discussion about it, because Mr. Farrow has undertaken a very careful study of the morphology and the topography with quite a careful photographic study. So we'll have another talk about that once we've been through that, perhaps. I'm grateful for that indication.
Thank you.
So with respect to my submissions, I did file them yesterday, and I wasn't sure if you would have considered them in any detail for bedtime reading or otherwise. But since you have read them, I'll step through them just to set the scene. But what I won't do is focus on the parts of the submissions that deal with the expert evidence, because again, you've read that as well, and we do have all of those experts here, and they're the best people to speak to it. So that's the back half of the submissions, really, was focusing on those key issues of evidence. But I will take you through some of the key messages, focusing on those 104D tests, because that is, I agree with you, where the issue is. And I've said in my paragraph 1.4, as a non-complying activity, really the primary issue is between council and the applicant is the potential impact on rural character, and that's really what I focus the submissions on, the split zoning and what that does in respect of the assessment of the application. My experts are there who will introduce themselves to you one by one. Section 2 of the legal submissions is an overview of the proposal, and again, all of the experts, including Ms. McGrath, have focused on that in the application and in their evidence. The site is partially zoned general residential and rural production, and that's following the recent suite of plan changes as part of the rolling review to the operative district plan. What I've explained in paragraph 2.2, which is quite an important part of the applicant's case, is that as a result of those rolling plan reviews, the surrounding area now contains a mix of zoning, which includes general residential, rural urban expansion zone, low density residential, some rural production and open space to the north. But what it really does, and you can see this quite clearly when you look at a zoomed out zoning map, is that the northern portion of the site results in an island of rural production just to the north of that site there, in an area that's just adjacent to that neighbourhood of Kamo, and an area where the plan has otherwise enabled quite a large degree of residential intensification. It's also identified in part that portion of the site as an outstanding natural landscape, an outstanding natural feature because of Hurupaki cone. The proposal is notified as there. The key thing in that part of the submissions is that since the proposal was notified and following submissions, there have been some revisions to the proposal just to reduce down the number of lots in that northern portion of the site, taking out another 3 lots north of the stream, realigning some lot boundaries and allotment areas, increasing some planting, and proposing some consent notice conditions to control the future built form in those lots north of the stream, and that's responding specifically to recommendations of Mr. Kensington. In the next few paragraphs of my submissions, and again speaking to the 104D non-compliant gateway test, sir, I've set out that the proposal contains various mitigation measures to manage potential adverse effects of the subdivision. That's core to this application and core to any non-complying application to get through those thresholds. And the team is collectively very comfortable that those extensive mitigation measures, including the proposed conditions, bring those effects of the proposal down to meet that no more than minor threshold. In addition, and it's a separate category because obviously positive benefits aren't weighed up in that no more than minor consideration, there's a number of positive benefits that contribute overall to a net benefit, we say, of the proposal, and that takes us more to the second gateway test in respect of objectives and policies. So I've done some work there to separate out, as I see it and as the experts see it, the things that form part of the proposal that mitigate effects in the normal way, and then those things that you might look at on top of those mitigation measures as really key benefits of the proposal. And that, I trust, will have come through in the evidence and on review of the submissions. Those benefits really are around connectivity of this development to this proposed development to the surrounding neighbourhood, but also being a site where that surrounding neighbourhood can connect through and up to Hurupaki and have an enhanced experience of that really key feature in the district. The 2 enhancement areas of Waitawa Stream and the Hurupaki Cone enhancement area are really, really key to this proposal. And again, that will have come through, I trust, in the package, because those really do set a really high water benchmark for the sort of enhancement that might not otherwise come with a generic residential scheme if you were confining things to that front portion of the site. Those enhancement areas would be very unlikely to form part of an application that was just meeting what the expectation of the general residential zone might see. So I won't take you through those one by one because I realise you've read them and we're stepping through a little bit faster. Section 2.9 of my submissions says that it will be apparent, we hope, that the proposal has been very carefully conceived as a whole, looking at the site holistically. So while the existing zoning pattern means that rural production portion of the site is not currently earmarked for housing, the team, when they sat down, carefully analysed the significant features of the site and the wider environment, looking at both portions of the site. And that revealed an opportunity to achieve significant environmental benefits if that residential activity wasn't snapped to the zone boundaries. So as a result, a limited number of larger lots have been proposed north of the stream. Still, as you'll see from the visual presentation that Mr. Farrow will take you through, the proposed subdivision, even in that area at the base of the cone, will be almost entirely screened from view from public vantage points by other residential development. Importantly, the proposal will create a high level of amenity and a park-like setting for future residents and homeowners within the site, but the applicant has been very careful to acknowledge that the opportunity to live and recreate at the foot of Hurupaki is a privilege. And so in recognition of that privilege, the proposal contributes to the amenity not only of its future residents on site, but to the wider neighbourhood and the residents of the district. And that's through the provision of public reserve that's accessible rather than gated away, park and playground areas, pathway connections through the community into the reserve beyond, and then the significant ecological enhancement and access to both the stream and the cone. So put another way, the proposal isn't being advanced on the basis of a bare minimum landscape concept and an over-ambitious subdivision plan attempting to maximise the number of potential lots, and we've all seen those. But this scheme instead has a thoughtful layout, reducing down the number of lots that the applicant might otherwise have put north of the stream, and very carefully positioning and using larger lots in that location to minimise impact. So as a result of that work and the design exercise, I'm really pleased to see that the issues remaining on foot between the applicant and the council have been narrowed and solely relate to that portion in the rural production zone. So section 3 addresses the section 42A recommendation. That report adopted a very balanced approach, acknowledging the myriad positive benefits of the proposal and carefully distinguishing between the two aspects of the proposal and the different zones, which I think was a very helpful approach to take. Although the majority of the report endorses the expert assessment on behalf of the applicant, the recommendation for decline, you will have seen, serves on two bases: that the rural production portion of the site was considered to have more than minor effects on that rural landscape character and amenity value, and that the objectives and policies of the subdivision and rural production chapters don't provide for this sort of development when it's considered that a net environmental benefit is not achieved. It is important to put those in context, though, I think, when making your decision and your assessment. The report and Mr. Kensington's landscape review do take that careful distinction between the two portions of the site, but I found some conflict in the report when it came to that key effects issue, when it was clear from the reporting planner that that quote that I've used there is that the extent of effects associated with the residential development in that rural production zone was considered to be difficult to quantify. And when we went through that analysis in the report, we looked back at the findings of the landscape review, and I think the difficulty comes, sir, from the fact that the landscape review placed a great deal of emphasis on the anticipated outcomes of the rural production zone, rather than doing that exercise of quantifying the nature and scale of effects that might arise as a result of the proposal. So what I found is that the landscape review quite quickly arrived at a view that the rural production zone doesn't anticipate development of this nature, and therefore the benefits couldn't be greater than the adverse effects, potentially a cart before the horse. But what I didn't see and what I couldn't step through was first an analysis of what rural character and amenity meant, both generally but specifically with respect to this site, because obviously rural character can mean a lot of different things to a lot of different pieces of land. We didn't see a careful analysis of the rural production framework, despite placing a great deal of emphasis on the anticipated outcomes of that zone. And there was no consideration that subdivision development can occur in that zone if biodiversity, landscapes, historic heritage, or significant ecology are protected and enhanced while maintaining those rural character values. There wasn't an assessment of the magnitude of the specific adverse landscape effects considered to arise from the proposal, not with reference anyway to the scale of effects utilised by Mr. Farrow in his original landscape assessment, and to which I'm used to seeing that sort of low, moderate, high level of effect. There wasn't a step through of the measures proposed to avoid, remedy and mitigate those potential adverse effects, and then an assessment of what remains. So looking at those residual adverse effects, which are really the ones that need to be no more than minor for us to pass through that gateway test. And also, you know, with the acknowledgement that this additional positive benefits of the proposal are significant, and that acknowledgement did come through strongly in the report, there wasn't a balancing exercise to show me how that conclusion was arrived at, that these significant benefits would not be greater than the residual effects that might arise. So despite that acknowledgement of those positive outcomes, the landscape review concluded the proposal was just too intense, and that in order to maintain appropriate levels of rural character and amenity, there was a suspicion that a much lower density would be required. And we tested that amongst the team, and you know, we had quite a lot of careful discussion about that. It was clear to me that the specific number of lots somehow was at the heart of the perceived impact on rural character and amenity. And that came through, and that there was an acknowledgement within the landscape review that some smaller or compromised or reduced number of allotments that might more closely reflect a lower density residential outcome, which is zoning adjacent to the site, might be more appropriate. But when we walked through that and tested it with the experts, I couldn't reconcile what particular mischief in the zone that compromise would end up addressing. And so to me, there's no good outcome of making a change just for the sake of change. So walking through that, there was no suggestion that reducing the number of lots would make the proposal immediately less visible. There was no real response to the visual simulations that Mr. Farrow will take you through, which demonstrates that low presence in the surrounding environment, which you'll know from your familiarity with the site. And there was also no suggestion, talking with the team, that reducing those number of lots, but still having some lots in that portion of the site, would be able to retain the site in productive land use. You can't do both. You've either got some allotments there or you're using the site, but the site is already, that portion of the site is already very small parcel of rural production land, so you can't really do both in that location. There was no suggestion that a rural productive or pastoral outcome would actually be a more positive landscape outcome, despite that framework. It's very clear that the revegetation and enhancement outcome is the positive part of this, and even it was deemed to be less positive that we couldn't achieve that on the entirety of Hurupaki because of land parcels. And there was also no suggestion that that reduced number or compromised number of lots would better protect and enhance significant ecological or biodiversity values. So I couldn't see my way through how a low density residential outcome would get us any closer to this rural production anticipated outcome. It just seemed to be change for the sake of reducing the number. And that is a perfectly understandable response in some respects, and it's one that you see quite commonly. Considering an application just feels too intense, and to seek to reduce it to something that's instinctively more palatable in number or in concept. But to my mind, for this application more than usual, that temptation to chip away at the number of allotments and achieve a balance somehow, it should be avoided. And I've called that death by 1,000 compromises. And that's because if you do that here, the associated benefits and very significant environmental enhancement will also be reduced. Because self-evidently, if you've got a relatively generic resi subdivision in the general residential zone, you don't, or just with a handful of houses to the north of the stream, you just don't need that comprehensive master planned landscape response. No applicant is going to put up that amount of enhancement, significant ecological restoration, reserve areas, and all of those other benefits. You'll just do your general residential subdivision and be done with it. I hope it will be apparent that a lot of care and effort has been taken by the applicant's team here to look to optimise those natural features that the site does have, while achieving consent for a sustainable level of development. A very careful balance has been struck in the opinion of this very experienced team, a balance which doesn't appear to have been focused on sufficiently, I say, by Council's reporting team, with respect, because Mr. Kensington does clearly acknowledge that significant benefit of the intended restoration of Hurupaki. But what there seems to be is a divorcing of those positive benefits and those really excellent enhancement outcomes from the fact that those form part of a holistic application that includes some residential development in that rural production portion of the site. So to my mind, reducing those proposed lots would end up with an inferior proposal. You'd load up more intensive residential activity in the front residentially zoned portion of the site. You'd reduce the landscape planting. You'd reduce the open space areas. You'd reduce that reserve restoration, and the remainder of that land would be put to some less environmentally beneficial or maybe a marginally productive rural production use. I say that the integrated nature of the proposal and using the entirety of the site for thoughtfully located residential development has enabled the applicant to maximise the environmental outcomes associated with the overall development. That is how a net environmental benefit is achieved by definition. It's how the plan seems to be constructed, to allow those outcomes to be granted consent when the benefits associated with those particular subdivisions or land developments wouldn't otherwise be secured. So that is the context that I say you should put the second recommendation in respect of objectives and policies of the rural production zone into context. I found on review of the report and the landscape review for council that the differences of opinion between Mr. Farrow and Mr. Kensington and Ms. McGrath and the reporting planner, all very experienced experts, ultimately underpinning the analysis of the 42A report were actually quite few and quite distinct. And so I've set those out there. Mr. Kensington identified that the rural production zone certainly has more than one theme, but then goes on to focus on continued rural use as a way to maintain rural character and amenity. So in doing so, he doesn't seem to have placed any weight on the provisions of the rural production zone that seek to promote and encourage the enhancement of significant landscapes, and then as a result, nor has the Section 42A report, as those overarching objectives and policies of the zone don't appear to have been considered separately from those relating to net environmental benefit. And then spatially, another key difference is there appears to be a divergence between Mr. Kensington and Mr. Farrow in respect of the relationship of that rural production portion of the site with the Hurupaki slope itself. So Mr. Kensington considers the site north of the stream to be a very contiguous part of that cone. And then finally, in respect of a key difference here, Mr. Kensington considers that the mapped extent of the outstanding natural feature and landscape doesn't fully capture the physical extent of the feature as it is, and therefore appears to discount the positive impact of the revegetation enhancement, as it will only achieve a partial restoration of those landscape character values, and the rest of the cone that's currently being farmed will continue to be farmed. So our evidence is focused in on those differences because that's where we could see a separation. Mr. Farrow and Ms. McGrath have gone very carefully through all of the relevant rural production zone provisions. And Mr. Farrow has, after undertaking that analysis, demonstrated that it's the restoration of the flank and the stream corridor that would provide an enduring rural character to that northern part of the site, and that the spatially and visually contained strip of land between the natural elements is of less prominence or importance when looking at that rural character and amenity. He's also undertaken a detailed analysis of the cone, including by these views and photographic studies that we'll come to very shortly. And he's concluded that the extent of the cone and the appropriate extent of the outstanding natural landscape lies further to the north than Mr. Kensington has settled on, leaving a portion of very gently sloping ground between the toe of the cone and the stream. And that's the portion where the allotments have been cited for the proposal, not on those steeper slopes of the flank. He's also addressed the mapping of the ONLs that he was closely involved in, and he has noted that the grazing and productive land uses of the cone were considered to limit the values of Hurupaki for the purpose of that exercise. And so in respect of considering the significance of the proposed restoration, he's only focused obviously on the portion that is within the applicant's control, because those sorts of enhancement efforts need to be undertaken one application at a time rather than disregarded with an all or nothing approach. So in my submission, in light of the considerable work that's been undertaken by the applicant team and in the reporting and evidence of Mr. Farrow and Ms. McGrath in particular, I say that you should prefer their evidence in respect of those key differences and generally. And given that the 42A report otherwise accepts that all effects have been appropriately addressed, when you give that weight to that assessment undertaken by Mr. Farrow and Ms. McGrath, that tips the scales, I say, in favour of the proposal on both the gateways. The next section of my evidence addresses just the legal principles in respect of those gateways, and I'm aware, so you'll be very familiar with the way that the court's considered those gateways for a long time. The approach is well settled, non-complying status. While you have to pass through one of those gateways, it's not intended to be a de facto prohibited activity. So provided on a holistic basis, on a holistic assessment, you can pass through the effects or objectives and policies gateway, then the application can fall to be assessed in the normal way under Section 104. I've set out some very established law for you in section 4, sir. I'm not sure that I need to take you through that because I'm aware you've read it and I'm aware you'll have had this spoken to you a number of times. But what I have focused on there is the broad judgment and looking at both the effects assessment holistically and also the objectives and policies test holistically rather than picking out one or two discrete effects or discrete policies. I've briefly addressed precedent on page 16 in 4.7 and beyond, as the section 42A report has mentioned the possibility for an adverse precedent effect if consent is granted for residential development in the rural production zone. Again, this is a concern that comes up regularly with an out of zone type argument. It's not referred to specifically in the RMA, as you know, the issue of precedent, but there is a long-standing understanding that it can be a relevant factor when you consider the likelihood of a number of other, sometimes opening the floodgates type discussion is mentioned, isn't it, in terms of those other materially similar proposals potentially coming forward. Again, the law here on precedent is well settled. Resource consents and the granting of a resource consent, particularly at council level, has no precedent effect in the strict sense. Each case, by necessity, depends on its facts. I've always enjoyed this concept that I've referred to there in 4.11, that just because the council grants one consent, it isn't to be assumed that they'll give up the ghost at that point and stop looking closely at every application that follows, because that's the council's job, not to rubber stamp applications that come through, but to carefully consider each one of them on their merits. Practically speaking, of course, no two applications are likely to be the same, although they may share similarities to a greater or lesser degree, and there may be influence as a result of those similarities. But of course, it's not the case that the grant of one subdivision consent in a rural production zone means inevitably any future application for residential development in the same zone can't be refused. There'll be a fulsome examination, and a residential subdivision in the middle of a very, very large piece of land zone rural production will be quite different to one on the edges of a residential settlement. So in my submission and on the evidence, this one in particular has a number of distinguishing features, and I've set those out there. The significant positive benefits and net environmental benefit is one. A number of those benefits are not just generically linked to planting, but are directly linked to the opportunity to enhance the values of Hurupaki Cone and Waitaha Stream, which are significant landform features and relatively unique within the district. Not many rural production areas will have the ability to propose such significant enhancement. And so it's unlikely that those opportunities would underpin a suite of similar developments or applications. If they do, the evidence is, and the reporting for council has acknowledged they might actually present a positive precedent rather than a negative one. I've mentioned there that although the northern portion of the site is rurally zoned, it's directly adjacent to the Kamo residential enclave, another distinguishing feature. Much of the rural production area, land in Whangarei is much, much further out. This one here is a logical extension of an existing neighbourhood, and certainly other areas would not have that same distinguishing feature. Also, the final one in this particular portion of rural production land, minimal productive value, given many things, the steepness of the slopes, the proximity to other established residential uses, which will create a reverse sensitivity effect, poor quality soil. So it won't be a case of this particular proposal undermining productive land resources, and another distinguishing feature. So the next two parts of my evidence here are the ones where I hadn't planned on taking you through in a great deal of detail, both because you've read it, which I'm grateful for, and because they deal with objectives and policies, and then the effects assessment. So these are taken through very carefully in the evidence, particularly of Ms. McGrath and then the experts that they come to. What I would say in this section 5 about objectives and policies is, again, in the section 42A report, there was quite a tight focus on a specific number of objectives and policies in the rural production zone, those relating in particular to net benefit, which thankfully Ms. McGrath is very familiar with and will speak to you about. But what the point I wanted to make to you here on the objectives and policies gateway in particular is that the assessment in the 42A report and landscape review seems to have glossed over the fact, or the very clear gleaning that I have from reading that zone, that rural character and amenity can be achieved in more than one way. And so there's been quite a tight focus on maintaining rural productive land use or only allowing subdivision if net benefit is achieved. But there's a clear theme to me coming through, and that starts with the issues on the introduction to that zone, that it's very important that the ecological and landscape values of the rural production zone are recognised and, where appropriate, protected and enhanced. Ecological and landscape values contribute significantly to the rural character and distinctiveness of the Whangarei district. And that's really key to me to this assessment of the zone. It's something that Mr. Farrow and Ms. McGrath have spent a lot of attention on, but that I didn't find the same attention in 42A or the landscape review. And so that's what I've focused on in that portion of the submission, sir, is to say that to my mind and in our submission, rural character could be achieved by farmed pasture or by a proposal that achieves significant enhancement of an identified landscape. And that's really what I take you through there and that section of my evidence. Ms. McGrath again does it in a great deal of detail. So I won't focus on repeating all of that for you, and also because I might be stealing a little bit of her thunder to come. Section 6 is the effects assessment, so the second gateway. What I've done at the start there is given you a list of all of the various categories of effect that the Section 42A report has concluded are either no more than minor or overall positive, which you'll see as most of them. The sole effect of concern is those effects on landscape, rural character and amenity in that rural production zone portion of the site. I've also drawn out in those parts of Section 6 the other key effects that were raised in submissions, because it's obviously, even if the council satisfied themselves in their reporting that those effects are no more than minor, these issues are equally of importance to the submitters who are also here. So again, I won't take away from the experts to come, but I've drawn out some key messages there on page 25 in respect of landscape, rural character and amenity, and concluded that Mr. Farrow is very comfortable and considers the proposal will achieve a benchmark for the district. Cultural effects on page 27, where we don't have any identified areas of cultural significance, but recognise that the border area is very important, and so there are some features surrounding and within the site which are culturally significant. What we've done here, in the absence of a submission from iwi, is sought to really focus on the effects of the development that were identified in initial consultation, and so looking to really respect and avoid development on the upper slopes of Hurupaki, proposing a great deal of enhancement and a focus on recognising the significance of the stream through active protection and enhancement there, and reducing the effects. Heritage, you'll hear from Mr. Carpenter, and that focuses largely on the dry stone walls, which are a real feature of the area. They will be an ongoing feature of this proposal if granted, and are a clear and very positive amenity feature of the neighbouring James subdivision, which is being undertaken by the same applicant. Transport, which has been raised by a number of submitters as well, and Mr. Scanlon's very comfortable that all of those effects have been considered carefully. Equally, ecological effects, which are addressed on page 30 and in evidence. So the conclusion on effects is that the matters of concern to submitters have been carefully considered. There's a number of conditions responding to those matters, and every attempt has been made to address those effects and ensure the proposal integrates with its environment. And in our submission, both the first and second gateway test can be achieved, and consent can be assessed under 104 and then granted. And obviously in this case, the effects and the objectives and policies are quite closely correlated, given the emphasis on the effects in the objectives and policies of the rural production zone. As you know, sir, if you can get through one or more of those gateways, preferably both. You can move on to a 104.1 assessment, and a full range of matters are available to be considered and assessed in that exercise. And I've set out on page 32 of my submissions the high points there in terms of that broad analysis. Obviously, many of the same things on the gateway tests will be very relevant to your assessment under 104 there. We say that the only outstanding issue with respect to granting consent is in respect of the effects in the rural production portion of the site, that the issue has been well and truly addressed by evidence. Are you still hearing me okay, sir? Still hearing me fine?
Yes, I am. Just had a momentary problem with my headset, but it's resolved now. Thank you.
Just in time for me to finish, sir. So I've just covered part 2 off very briefly. We don't rely on it. Section 8 of my submissions just refers you to still in business? Still hearing me all right?
Oh, yeah, I'm hearing you fine, thanks.
Section 8 just refers you to the conditions attached to the evidence of Ms. McGrath, which, as noted in the report, the reporting planner has indicated could form the basis of your decision to grant. Those have been updated since the original conditions that went in with the proposal to respond to some matters raised in submissions and by Mr. Kensington. And Ms. McGrath can take you through those in any detail if you wish to look at step through them or have any specific questions. So that is the conclusion of my submission, sir, in respect of opening. I'm happy to take any questions or address any of those matters in more detail with you, or if not, my first witness is Mr. Holland, the applicant, who's in the room with me, and I can spin the camera around.
Just before you do, I wonder if I could just tag a couple of issues more for your witnesses, but just so they know there are issues on my mind.
That would be very helpful, sir.
One is, you said in your paragraph 413 that the higher land on the slopes of Hurupaki is not suitable for cattle. I'd be interested to know in due course what is being grazed there at the moment, and just some comments around your assertion about cattle. Well, what about other grazing animals? And that leads to another issue, which is, if this application were declined, what is likely to happen? Which I think is a relevant question. And the landscape and planning witnesses might like to comment for me on that, what is likely to happen, and what would be the pros and cons in environmental terms of either course of action in the future.
That's helpful, sir. Mr. Holland himself can speak to the cattle grazing and what's likely to happen from his perspective if the application's declined. And then with that guidance from you, Mr. Farrow and Ms. McGrath can speak to the relative pros and cons of that outcome. But certainly Mr. Holland has turned his mind to what he would do with the site if it's not this. So with that context from the applicant, then the experts can speak to you about the potential effects of that. That's very helpful.
I'd also like to hear from Mr. Holland, which I may be preempting his evidence, but I'd like to hear what other land he owns in the vicinity, or his company or associate companies, and a little bit about the James subdivision next door, whether he's involved in that or not. But that's just to help people to address issues which are on my mind, which I guess my mind is important in this process.
Certainly is, sir.
So just before you call Mr. Holland, if we were to take a break, just bearing in mind people's needs to do other things briefly, if we take a break after Mr. Holland's evidence, would that be suitable?
That would, I was going to say, so we didn't quite touch on morning tea, lunchtime and afternoon tea, as we usually see how the experts go, but Mr. Holland, I don't think will be terribly long. So if that works, we can do that. And then Mr. Farrow, that will give Mr. Farrow a chance to get his screen up and running. He's going to share his screen for the visual presentation. So that might be a very good time.
Excellent. Thank
Great.
you.
I will swap seats with Mr. Holland now and pop him in front of the camera for you.
Thank you. Good morning, Mr. Holland.
Good morning, sir. How are you?
Fine, I hope you are too. I'm looking forward to what you have to say for me.
Yeah, well, yeah, welcome everyone. I'm not accustomed to doing this all the time, so might be the odd pause. And I tend to be the person out in the field rather than speaking to a number of people through a Teams meeting situation, but we'll see how we go. So what I've done is put together just a summary of the evidence that I had put together with our application. So I'll go through my summary and then I'm happy to maybe touch on some of the things that you raised there at the end of the last presentation. My name is Mark Anthony Holland. I'm one of 3 directors of Hurupaki Holdings Limited, and I'm also the principal and project manager for the current application. The site was purchased in 2020 as an in-zone residential project with the potential to be around 60 to 66 lots. The site at 189 3 Mile Bush Road, which is the 9 hectares of land to the north of 131, then became available. My vision is to use the original 5.9 hectares site plus approximately 2 hectares of the flatter contour land at 189 3 Mile Bush to complete a high quality proposal with sections ranging in size from 400 to 1,000 square metres. The master plan allows density to be spread across the site as a whole instead of concentrating the development in the general residential zone. This has resulted, in my opinion, in a much better outcome for the front area of the site and the development in its entirety. While 189 3 Mile is zoned rural production under the district plan, the 6 hectares on the cone of the mountain is not ideally suited to cattle grazing because of its contour being steep, inability to fertilise effectively, soil type is not conducive to animal production, and the small scale of the property, and the fact that it is going to be surrounded by residential housing in the near future. The proposal is very focused on connectivity with the wider community and on various open spaces throughout the site. The proposal is to the west of the James subdivision. The 2 subdivisions will share a common boundary of approximately 900 metres. When completing the design in the James, we created access ways between both projects, allowing internal access to the Hurupaki school, which means children can walk or ride their bikes to primary school without leaving the subdivisions. This will create connectivity between the 2 developments and provide close to 3 kilometres of walkways for the public to enjoy. We intend to plant the balance of the land to the north of the sections on 189, which will also provide some nice walking tracks and bring the cone of the Hurupaki mountain back to what it used to be. We also have a number of open spaces, including 3 stormwater attenuation ponds, which we intend to become features of our project. A playground to the northeast of Hurupaki and an open space green reserve of approximately 6,000 square metres around the Waitawa stream, which is very easy to access from both Hurupaki and the James. Mr. Kensington has suggested that a lower intensity of proposed development may be acceptable to him on 189 with fewer lots of a larger size. However, to further reduce the number of lots on the site would put the entire feasibility of the bulk project at risk. Given the numerous community outcomes, positive benefits and mitigation that we are proposing as part of our overall subdivision, this is simply not a case where the lot numbers and sizes can be reduced while achieving the same outcome. We genuinely believe we've put forward the best possible proposal for the site as a whole and have deliberately avoided trying to cram in extra lots that our expert team cannot support in this location. The purpose of the master plan development was to ensure we were comfortable that the number of lots proposed could support the positive community environmental outcomes, no more than that. In the event the application is declined, it would not be viable to continue on with a smaller version of the current proposal, i.e. retaining all the positive benefits, planting the Hurupaki slope, enhancing the stream, with a fewer lots proposed. In reality, we would have to resort to a standard residential scheme in the front portion of the site, being 131, Zone Resi, which in my opinion would be a disappointing outcome for the community and I think the wider environment. Let's close off that I feel the proposal incorporates a significant number of positive benefits for the broader community and hope throughout the hearing we can prove that our proposal is worthy of your support, sir. Thank you.
Thank you. You may not be familiar with this sort of hearing, but you did exceptionally well, if I may say so.
Thanks very much. Yeah.
I would like to just clarify, I think I understand that the James subdivision is also your company or an associated company, is that right?
That's right. So just to very quickly, there are 5 shareholders in that one. 3 of the shareholders in that company are the owners and directors I spoke about at the start of my presentation. So yeah, and I was the project manager and principal for that one as well, sir.
Thank you. The matter I raised with Ms. Lupus of cattle, would you agree with her assertion that the upper slopes are unsuitable for cattle grazing?
Yeah, well, in my evidence, if I can, in my evidence that I gave, my background is I am a farmer, and just to give you the team an update there, a dairy farmer since I was 15 for so a long time, also cattle farming and a sheep farmer. The cattle, the cone that lies to the south is very steep for cattle. At the moment, or when I bought the property, there were 9 animals grazing on the property, and there had been for a long time. The driveway, which is the entry, which takes up close to half a hectare, was mown, so it's a driveway mown, then a home, so it leaves around about 7.5 hectares of grass covered land. And the cattle on this sort of stuff, sir, tend to do what we call cattle rutting. So they don't walk up and down, they walk around. That's how cattle traverse.
Yeah, I understand the concept.
Yep. You raised the issue as well in regard to other possible animal uses. Now, while it will carry 9 cattle, if you use a factor of 1 to 5 for sheep, you could potentially carry 30 to 45 breeding ewes, or potentially fatten some lambs. But the issue that you have there is that the property is not set up for sheep, and sheep are quite high maintenance creatures, and it would be quite intensive to create yards and fencing for sheep. I don't think you could look at deer, and I suppose then you start to look at the other things, maybe llamas, or I'm not sure, but I don't think it's the right sort of property for that. That's in my opinion.
So do I understand correctly, there are cattle on it at the moment, but you don't think that's a sustainable long-term option?
No, I don't. No, I don't for that property.
No.
And if you were to graze the small area in the front, sir, you would be looking at 2 or 3 cattle.
Right. The land immediately to the northwest, do you know what ownership applies there?
As far as I know, it's not an owner operator. It's someone that owns the property that lives in Auckland, and they rent the house out. I just check, that's the piece that's zoned future large residential. Yeah. So in the future it can be larger residential, rural residential, I think they call it, sir. But I'd stand corrected on that by Mr. Hartstone might, or just
rural.
Yeah.
Well, thank you very much. I appreciate your evidence, and I don't have any further questions. Does anybody else wish a question to be put to Mr. Holland? If so, now is the time to raise your hand or attract Ms. Wilson's attention. It appears not. Your evidence is clear, and I thank you for it. If anything crops up during the remainder of the hearing where I need to ask you a further question, I presume I'll be able to do that through Ms. Lupus, but thank you for your contribution at this point.
Thank you, sir. And if there's anything else about the agricultural side of it, happy to put my thoughts forward. Thank you very much.
Thank you. So, Ms. Lupus, would you like to call another witness, or would you like to take the morning break now?
Given that Mr. Farrow is next, sir, and he will take quite some time, I think we might run through him after the break and just have him together. So if you're happy to take an early break, then we'll get Mike's screen up and running and ready to jump to that visual presentation.
I'll check back in with you at 10:25 with the hope that we'll start about then, or 10:30, depending on Mr. Farrow.
Perfect. Thank you, sir.
So thank you all. We stand adjourned until 10:25.